Learning objective 4, distinguish among the types of tangible evidence. Okay, tangible evidence, physical items that may be presented at trial for the jury to consider. As opposed to documentary evidence, which are writings, recordings, and photographs, includes X-ray films, electronic recordings, or any other data compilation. Demonstrative evidence. Those are the tangible items such as photographs or maps that depict, display, or demonstrate a fact. They demonstrate the fact, they're demonstrative evidence. Physical evidence. Any tangible physical evidence, usually an item directly related to litigation. The broken pipe, the broken bicycle, those sorts of things. Learning objective 5, describe witness testimony and how credibility of a witness is challenged. Okay, testimony evidence is evidence given by witnesses who usually appear live in the courtroom. You've seen it on all sorts of TV shows. It's the most common form of evidence. All witnesses must take an oath or make an affirmation before testifying. They don't have to put their hand on the Bible, but they have to do something. It also lets them know that they can be criminally prosecuted for lying on the stand. Now, the question is directed by the attorneys. They will have questions on direct and cross-examination. Direct means that if they're a witness for the plaintiff, the plaintiff's attorney gives them direct questions. Cross-examination will be the defense attorney's attorney. And these are often open-ended questions during direct examination and leading questions during cross-examination. A lot of what goes on in cross-examination is trying to take away the credibility of the things that they said in the direct examination. Lay and expert witnesses. A lay witness is a person who has personal knowledge about the matter before the court. They're a witness. They were directly impacted or they saw something. Those are most people. An expert witness is a person qualified by education, training, or experience to render an opinion based on a set of facts that are outside the scope of the knowledge of the fact finder. So maybe if it involved like something with the car, your automobile, a lay witness would be the mechanic that looked at it. The expert witness would be someone who was an expert in the design of automobiles and could say that how the manufacturer designed that vehicle in a dangerous manner. Okay, challenging the credibility of witnesses. You don't like what they said and you don't want the jury to believe them. So you call into question the credibility or believability of the testimony of the witness. You can look at some of the things they said out of court that may contradict what they're saying in court. You can bring up a criminal record. It's especially pertinent if it's something where they lied, fraud, any sort of things like that. Religious beliefs. You have to be careful with religious beliefs. Character and habit. Hey, everyone knows this person's a liar, and they're frequently paid for their testimony. Identify types of hearsay evidence and the important exceptions to the hearsay rule. Okay, hearsay is an out-of-court statement made by somebody, declarant, other than the witness testifying. The statement of the declarant is offered for the truth of its contents. Hearsay is inadmissible unless an exception applies. Okay, so what would this be? My friend Janice told me about the wreck that she saw. That would be hearsay. I was not a witness. Janice was the witness, and she just told me this stuff. So that's hearsay, and it's inadmissible. Hearsay may be oral, written, or nonverbal. regarded as unreliable because the declarant is unavailable for cross-examination. In my example, Janice should be the one who be on the testifying about what she saw, not what I heard her tell me she saw. Non-hearsay items that are not hearsay because the declarant, while presently not testifying, is available to cross-examine about the statement. So maybe Janice is in the courtroom and can be brought up about what I said she said to me. Statements made under circumstances where it is unlikely the declarant would fabricate the statement. Usually that's like an admission of guilt. If I said to somebody, hey, they told me that they killed blank and blank, that might be, allowed, because why would the person admit to guilt unless it was true? There's a list of exceptions to the hearsay rule. You'll find them in the book. A lot of them have to do with either excited utterances, deathbed statements, or things that were really kind of public knowledge anyway. Okay, so that finishes up this chapter. Good luck with the assignment.